I would first like to extend a sincere thank you to all of our panelists this morning. We are looking at the decriminalization of LGBT conduct and the destigmatization of LGBT status within the Caribbean as part of the broader rubric titled Tides of Change. Of course, many persons would be aware that the world, generally speaking, the legal norms and the attitudes concerning the criminalization of various forms of LGBT conduct or status has been changing. Some places more so than others, or more quickly than others. And one of the things that we had always been interested in discussing was what that specifically looks like within the Caribbean context. And we've put together an extremely high-level expert panel of persons to discuss various issues around those themes this morning. I will shortly introduce our panelists, but first I wanted to thank the organizers of this event, ECADE, the Eastern Caribbean Alliance for Diversity and Equality, which Kenita represents, as well as the Pan-American Development Foundation, who were also instrumental in organizing today's panel. So thank you again to the organizers and to the panelists and to all our listeners regionally and abroad. I will now introduce our panelists for today's session before we officially begin. Mr. Andrew Pilgrim has been a criminal defense lawyer for 25 years. He has sat on the Commission for Penal Reform, on the Commission of Youth Affairs, and was a commissioner on the inquiry into the Child Care Board. He is currently one of the steering committee members of the Barbados Drug Treatment Court and is a former president of the Barbados Bar Association and now sits on the steering committee of the Justice Improvement Project being administered by the Caribbean Court of Justice. Mr. Pilgrim is also a Queen's Counsel and, as indicated, is based in Barbados. Ms. Tracey Robinson is a Jamaican attorney and lecturer in the Faculty of Law at the University of the West Indies, Mona campus. She has served as a commissioner on the Inter-American Commission on Human Rights from 2012 to 2015, and in 2014 was elected as chair of that organization. Ms. Robinson has served as rapporteur on the rights of women since January 2012 for the Organization of American States and has helped establish the rapporteurship on the rights of LGBTI persons, serving as its first rapporteur. Ms. Robinson founded the University of the West Indies, Europe, the University Rights Advocacy Project to promote human rights. Mr. Dashan Ramdani is a senior attorney at law with considerable experience in public, constitutional, and commercial law. He is the current Attorney General of Grenada and has worked as a defense lawyer in capital offense cases in Guyana, prosecuted at senior levels and has prosecuted at senior levels in Guyana, Grenada, and Turks and Caicos. He is admitted to the bar in Guyana, Trinidad and Tobago, Grenada, and New York, and is the author of a legal textbook, Confession, Evidence, Practice and Procedure for the Commonwealth Caribbean. He's also a member of the peer review group of the Commonwealth Law Bulletin and has served as a sitting judge. I believe it would have been in the jurisdiction of Guyana. Ms. Veronica Cenac is an attorney at law with over 21 years experience. Her substantive occupation is as a practicing barrister, solicitor, notary public, and legal consultant in the firm of Law Solutions Incorporated, which was preceded by 6 years as a Crown attorney in Saint Lucia. Ms. Cenac possesses over 17 years experience throughout the Caribbean and Latin America on legal and policy analysis related to HIV and human rights, sexual and reproductive health, and sexual orientation and gender identity. She is a founding member and currently serves on the board of the AIDS Action Foundation Saint Lucia and the Caribbean Vulnerable Communities Coalition. She also serves on the board of the Canadian HIV/AIDS Legal Network and the PAHO Regional Validation Committee for the elimination of mother-to-child transmission of HIV and syphilis. Ms. Zita Barnwell is a barrister at law and solicitor in the areas of litigation, civil and criminal, experiencing human rights, resolution of disputes, and mediation. She has over 7 years of experience in building partnerships and project development through leading multi-stakeholder development management and research projects. She also possesses direct experience in foreign direct investment attraction, business climate, and business and climate improvement. So I would like to say again, thank you to all of our panelists. And we will now kick off today's session. I believe we may still be waiting on Mr. Pilgrim. So I would like to kick off today's session with a question to Ms. Robinson, who actually taught me human rights law in the University of the West Indies, Barbados, where I had studied law and where she was then a professor. So the first question, Ms. Robinson, is, during the past few years, there have been various attempts by Caribbean countries to amend their constitutions, to make them possibly more progressive or more modern, all of which more or less had failed with the exception of Jamaica, which some would argue amended their constitution to make it actually more homophobic. What do you see as some of the major issues which prevented the proposed constitutional amendments from passing? And how do you think in future governments can operate so as to ensure or make it possible for positive constitutional changes to occur within the region?
Thanks very much, Richie. And many around the room have been engaged with some of the processes of constitutional reform. I certainly think both Kenita and Veronica, in the context of Saint Lucia, every single Caribbean country has been thinking about reform over the last few decades, and many intensely in the last, I would say, last 2 decades. I think the only place that has managed to succeed using a referendum vote to achieve reforms recently has been actually the territory of Cayman Islands. And that tells us some things. I think the first thing is, what does it take to introduce reforms? And the reforms that have required popular votes have been astoundingly unsuccessful in the Bahamas, in Grenada, of course, in Antigua and Barbuda. And so the methodology for reform will make a difference, and that's mostly determined by Caribbean constitutions. But let's think about, apart from whether we have succeeded, I would say the reform process is mixed. The reform process, on the face of it, appears to be progressive, offers strongly the language of human rights and sometimes internationalism, but often is mixed with regressive reforms, as you saw in the case of Jamaica. And you certainly saw that elements of this in the Saint Vincent and the Grenadines constitution. And I suspect all reform processes will have to be extremely attentive to questions of definition of discrimination, the scope of the rights to equality, the nature of exceptions being made to the rights regime, particularly for queer persons, for women, which is historically what has happened in the last 2 decades, and particularly a flashpoint, not only in the independent states, but in the territories, is the question of the status of same-sex unions, which has received significant negative attention.
Right, I see what you're saying. No, just given that it seems that by and large, our efforts to amend the constitutions in a progressive direction seem to be failing, perhaps very much because that it requires a public referendum. What role do you see litigation as playing in extending access, rights, justice to minorities within the Caribbean?
So I would say, in my view, Richie, the two are connected processes. And that was one of the humbling lessons in litigating, for example, Belize. I think litigation opens up avenues where constitutions are sufficiently broadly worded to make better sense of our expectation that everybody's somebody. that all are equal in the eyes of the law. So I think there are opportunities there, but I think we also know in countries, if you take somewhere like Belize, where constitutional reform is fairly easy. So you compare Belize to Saint Vincent and the Grenadines, for example, where a referendum is required. In countries where reform is fairly easily achieved, the risk is that if courts make decisions which are not liked, there will be reform processes which reverse that. And we've seen some of that in the case of death penalty in Barbados, in Jamaica, and other places. And we also want to be alert that litigation also can carry the risk of negative responses if it is felt the courts have moved too far. And that's why it's such a process which requires such careful calibration and the kind of work which ECADE has been doing in working inside as movement with communities and with societies to advance the kind of changes through the litigation process.
Okay, I see. All right, thank you very much. There is much that has been stated which we can raise questions for, but just given the tightness of our time this morning, I'd just move on to one of the other panelists. Thank you very much, Tracey. Mr. A.G. Ramdani, good morning. Mr. A.G.
Yes, good morning. Morning, Richie. Morning, everyone. I'm very pleased to see you moderating this program, which you know better person. You know the reasons why you are making strides in human rights in, enhancements and respect for human rights in the region. I want to correct something before I quickly proceed. I have been an acting judge, but not in Guyana. Okay. I have been an acting judge for over 30 months in the EC territories, including Saint Lucia, Antigua, Anguilla, BVI, and St. Kitts and Nevis. Yes, so I wanted to actually comment at the end of the first question that you asked Ms. Robinson about the failing of various attempts to amend the constitutions.
Right.
I think what needs to be underscored is that it's a terrible thing that these attempted reforms have failed, but it must emphasize the will of the various governments to take that step. It must be recognized that the governments of the region are giving due regard or attempting to give due regard to fundamental rights, human rights, and respect for all. When they attempt to, when they insert these provisions, and you know, we have had our experience in Grenada, and one of the criticisms or statements following the failure of the 2016 attempt to amend the Grenada Constitution was that we had there in that amendment one related to gender equality. And you know, the reforms failed, and part of the blame was laid at the feet of that particular provision. And so, but the point I am making is that it was, I mean, we'll have to find ways to get it right. But the governments have been making efforts, real efforts. Richie, you personally right now involved as legal consultant for the Spotlight Initiative relating to violence against women and children in Grenada, where we are looking at examining all our current laws and to come up with a program to protect women and children against all forms of violence. And this particular area will also be tackled in that process. So even though we are unable to get where we want to go yesterday or last year or 2 decades ago, we are indeed making strides by recognizing and by finding innovative ways. And we will speak more about that as we go along. Yes, thank you, Richard.
So two questions. Thank you for that contribution, but I also had 2 specific questions for you. One coming out of what you indicated. Now, in the Grenada experience, the various proposals for amendment were all disaggregated. So it's not that all were lumped into one bill that people had to vote yes or no on. And persons voted no for things like term limits, on being Prime Minister, or even the name of Grenada to include Carriacou and Petit Martinique, which are our sister isles. So there seem to have been just a general no. Do you think that there were political processes at play in frustrating the efforts to amend the Constitution, and how might we be able to overcome them in the future?
Well, I am not a political attorney general. I am a technocrat. And I would suggest that any attempt to amend any law always, especially the Constitution, always becomes a political matter. Opposition, other parties who are not in government, usually see a government that gets a constitution amended makes a political statement. A government that gets a referendum from the people of any country is a government that has gotten the support of at least that majority of that huge majority of the population. And usually that makes it virtually sometimes impossible, at least in the next term, for any opposition party to retake a government. I don't wish to say that opposition parties are only concerned with getting into government, but their arguments for on both sides and on many sides for any issue. So happened that every referendum that was attempted in the Caribbean recently, the opposition parties, sometimes seeming to support some of the issues, would ultimately do quite a bit to resist these changes. And so I think education, awareness, sensitization are very key elements of this. But when you're dealing with the population, it depends on who they're listening to. And if they blink, and if they moving, the government that moves the process, the moving government doesn't get that that campaign just right or perfect. Let me say, if they don't get that campaign perfect, sometimes it fails not because people may not be buying in, but it's simply like the other messenger with the message coming from the opposite side. Because you talk to people on the ground, and there are quite a lot of people who will sometimes say, well, I didn't quite understand that is what was going on. You hear those comments, and this is after 3 months, 4 months, 5 months of public sensitization. And so you wonder, well, where were the messaging going? So I say to you, yes, it always becomes a legal issue. And we as stakeholders in the process, both public and private, need to play a role. All of us need to come out and play a role when these issues are being raised, and not leave it to the government. A referendum or a constitutional change should not be dependent on the government's ability to move the people, but on the people's ability to want change.
Right, I understand. And my final question for you, Mr. E.G., is just given the difficulties or reluctance of our regional legislators in decriminalizing LGBT behaviors or status through laws, we see that there seems to have been some success in having that decriminalization done through litigation cases. Just given your understanding of where the international human rights norms and precedents are to current date, do you see the government of Grenada as resisting a challenge if one is brought in the context of Grenada? Do you think that it would be your office's position that you would actually defend such a challenge?
Richie, I think cabinet will ultimately have to weigh in on an issue like this. The government of Grenada, I believe, is a responsive government, a responsible and a responsive government who has in various ways kept its pulse on the international trends, the regional trends, the international global jurisprudence. And so we see this, but we continue to be a sovereign nation, and we continue to have to listen to the wishes of the people. Grenada is a largely conservative society, and we have, if the referendum was anything in the context of this discussion, it was a thermometer to test the temperature of the population in relation to their readiness for this type of change. So you and I have heard our Prime Minister and all members of Cabinet from time to time publicly affirm our respect for human rights and to denounce all forms of discrimination. But we are dealing with a specific issue. You would know, I think, or you may soon know, depending on the depth of your research so far, that of the various cases we have had in Grenada relating to that particular section that criminalized, we call it unnatural connection in Grenada. And whilst people have been prosecuted successfully for it, there have been instances when the director of public prosecution have taken, I believe, a public position, which is that to not continue with, at least in one particular instance, not continue with a particular prosecution having regard to the charge that was brought. I don't see any eagerness to pursue prosecutions. How we will respond to litigation that challenges provisions will have to have the blessings of cabinet, and that will have to be a long discussion on that matter. I do say to you that we are taking many steps to address various components of our law and practice in Grenada that reduces discrimination, that accords benefit and protection to people in this community. So we are a responsive government, and I hope that we continue to take great strides in this regard.
Okay, thank you. Now, just one final question based on something that you raised, which I think is quite relevant. You indicate on the one hand, the government's responsiveness to international laws and willingness to protect the rights of persons in Grenada, but you also indicated that the response to a potential challenge would have to do with, among other things, feeling the pulse of the people, in essence, what feedback people give. Do you think that it is fair for a country to determine what rights minorities have based on a majority position?
No, I think if you understood me to say that we will decide whether to challenge depending on the pulse of the nation, I meant that the cabinet will have to make that decision whether we turn up in court. And let me say this very practically, whether we turn up in court and say that we have no objection to this application being made, or whether we turn up with written submissions, we analyze our constitution, and we lay it before the court, the legal issues. And that is what I meant. I did not mean that the government was going to hold a referendum and test the pulse of the society. We have done that, Richie. We have done that, and you see what has happened. And that was every man, woman, and well, person trying to be as gender neutral as I can be, that voted at that referendum had a say. They were a judge at that point in time as to where this fell. Yes, everyone that voted. So what I mean to say is that there are several ways one can approach litigation. We can turn up in court and we can offer all the various views on the opposite side and ask the court to make a determination. And that would not mean at all that we would not have respect for rights of persons. It must also mean that we are also according respect to what we understand our current laws to be. Yes, we have a constitution, we have various laws that have been on the book for decades, and our society has been carrying on its business in a particular manner. So I can't sit here and tell you that cabinet will simply say, well, let's not put any objection forward. But I do not mean to say at all that any court case will depend upon what the majority in society say. Our government is elected, Richie. I know I've been going on. Please forgive me, panelists and all members. Our government is elected because they represent the will of the people. Now, there are many major matters and matters such as this when you're making decisions, when public consultation is necessary. I have never known any government to engage in public consultation to determine what to do with a court case. We would not do that. Yes.
Okay. All right.
Thank you.
Thank you. Thank you very much. Thank you very much, Mr. AG. The next question I have is to Ms. Cenac. Now, Ms. Cenac, I know that you've been involved to various degrees in the preparation and otherwise of some of the cases in the region. What I wanted to get from you is a sense of, beyond the legal technicalities, what documents you have to draft and file. And so in terms of the buy-in of the wider LGBT community into a particular case, how important is that? And also, what is the role or function of interested parties in such cases?
Mm-hmm. And thank you, Richie. This question is really specific to the setting that you find yourself in terms of the wider community involvement. The OECS countries, the Eastern Caribbean, we are in a particular circumstance because we are very small. Our communities are very small and also very visible, although they can be invisible, but they can also be very visible. So we have to be careful about taking a strictly sort of lawyer-client approach, where regardless of what the situation is with the community, that we go ahead and file a case. When we file that case, it is the entire community that will be impacted. It is a young person who's walking on the street. Most of the time, somebody who's already vulnerabilized because they have been put out by their family. They are not working because employment is difficult for them because of discrimination. They have been victims of other forms of abuse, etc. And so you expose that person when a case is being filed in a highly religious society that we have to further abuse. So we have and I have a presentation that speaks to this, a question about doing no harm. So we have to be cognizant of that. We also have to be cognizant of, if you want to call it, the optics in terms of the filing of the cases. So the protection of the litigant, ensuring that the litigant is prepared. And in terms of the interested parties, we have had in some of the cases, particularly in Belize, a sort of a set of interested parties that on one side, religious organizations, on the other side, international human rights organizations. And so the interested parties can also aid your case, but can be also detrimental, and how to manage that process. So, and I'll speak to that in the presentation I'm going to give, but in a sense, the interested parties are relevant and important, but we have to balance it out. We are attempting to not to take away the specter of the argument against filing these cases, that it is being promoted by external forces, you know, the international human rights organizations, and that it is something, and it is an imposition on these countries to have those fights. Right. So the types of interested parties and the numbers that we have are going to be important. We have sought to focus really on local expertise and local organizations to be interested parties on some of the new cases that are going to be filed.
Okay, thank you very much. And you indicated that there was a presentation that you prepared on doing no harm.
Yes.
Right. Would you like to take us through that presentation now?
Sure. Right. Kenita, I don't know if you could put it up, or do I have permission to share the screen? Is someone sharing the screen? Because I can't share this. I don't have permission, I think. Right.
You're getting through? Okay, perfect.
Yeah. Okay, so this is a very brief presentation, and I hope I get to go through it very quickly. Next slide is on, it's looking at the ECADE strategy in terms of addressing strategic litigation, and just a little bit of the landscape in the Eastern Caribbean, that in the Caribbean, right, English-speaking Caribbean, that we have buggery or serious indecency or gross indecency is an offense in 9 of the countries. It used to be 12 countries, we're now down to 9. So it's legislatively prohibited in the Bahamas and through court action in Belize and Trinidad and Tobago. The penalties range from Barbados and Guyana life imprisonment And most of us in the OECS, it's from 5 years to 10 years. Next slide. So we do have very few anti-discrimination laws covering sexual orientation. There are 2 exceptions, most recently in Barbados, the Prevention of Discrimination in Employment Act, all passed this year. And in Saint Lucia under the Labor Act, which came into effect in 2012. There are specific mentions of non-discrimination on the basis of sexual orientation in both of these pieces of legislation. Otherwise, Belize and Trinidad have immigration restrictions on the entry of homosexuals, and that was one of the cases that were filed by Maurice Tomlinson, both unsuccessful. We have no recognition of same-sex couples, no adoption by same-sex couples. And in our laws, while transgender persons can change their name legally by deed poll or by order of court in some cases, there are no legislative provisions allowing you to change gender markers on civil status records. Next. Next. So the socio-political landscape, we have highly religious societies where law is conflated with religious morality based on Judeo-Christian norms. And there is little political will to make legislative change. Of course, the big exception is the Bahamas, who did that in 1991, quite early. But generally speaking, where we've had success has been through legislation. There are significant cultural taboos, myths, and misconceptions around sex, sexual orientation, gender identity, even issues of comprehensive sexuality education for adolescents, and what ought to be included and what ought to be excluded is a difficult issue to navigate in the Caribbean. And of course, intolerance and misconceptions on human rights principles. Next. I wanted to give an idea. This is some recent studies that is not well published. To give an idea, when we talk about the MSM, LGBTI communities, particularly the OECS countries, what are we talking about? There was a question in other panels hosted by ECADE as to whether or not, for example, there were transgender persons in the OECS. And so as part of the Global Fund project, the OECS Commission, as the principal recipient for the Global Fund, conducted a behavioral survey and population size estimate implemented across the 6 independent countries of the OECS for men who have sex with men, MSM, trans women, and female sex workers. And the next slide is on, we'll look at some of the findings from that behavioral survey and the numbers. So you can see the numbers that were found in each country. There were 4 sort of methodologies that were used, and then there was analysis at the end where they estimated what the size of the populations were in each country. That is for MSM. There are lots of issues around the numbers. They seem high, but it gives us a sense of the numbers that we have, considering the populations that we have in these countries. It is high. Most persons are underground, but at the same time, they can be easily exposed. Next slide. Some of the key findings. In terms of violence and discrimination, 13.1%, and that's across the general, across the 6 countries. 13.1% felt that the police refused to protect them because of their being gay or MSM. 4.3% reported being detained or arrested on charges related to homosexuality or other related charges. AG Ramdani prosecution of cases in Grenada. 7.1% they had been harassed or intimidated by the police or immigration officers for being gay. 46.7% reported being verbally harassed or insulted by someone for being gay. And 22.3% reported being physically hurt, that is pushed, shoved, slapped, hit, kicked, choked, or otherwise physically hurt by someone for being gay. What is not on that list is the number of deaths we've had, which we are compiling. In Saint Lucia alone, we have recorded over 10 deaths between 2005 to the present that were directly related to the person being gay, all male in these cases. And it excludes suicides. Next slide. 26.0% reported feeling scared sometimes walking around in public places because of the treatment they might receive for being gay. 22.4% of MSM and trans women reported sexual abuse, with 11.4% attributing it to their sexual orientation, and 6.9% believing it was unrelated to instances of sexual abuse, and 4.1% being unsure if it was related or not. 11.1% felt that they had overtly been denied a job because of their sexual orientation, but 14.4% suspected they might have been. We did have it was ultimately settled by the case in Saint Lucia, where on the basis, the claim was brought for wrongful termination on the basis of unfair dismissal on the basis of sexual orientation, but that matter was settled, went before the Labor Tribunal. It was clear that a case was established on the provisions of the Act. Next slide. So that's the key findings on the size estimate population studies. There's a wealth of information in those reports, and I'd encourage everybody to get a copy to look at them. So just in terms of what we have so far in the region, and Tracey could correct me if I've missed anything. So there are 9 cases that are currently ongoing or have been decided. There's an Inter-American Commission on Human Rights case from Jamaica, which is pending. Then there was a case in Jamaica on the challenge to buggery, Javed Jagai. That case was withdrawn, focusing on privacy. And 2 cases, Tomlinson and TV stations in Jamaica. These were lost. The Court of Appeal gave a decision just recently. And I think Richard Elliott from the network, legal network, is on the call, and he could also speak to that. Maurice Tomlinson, these were the immigration cases filed against Trinidad and Tobago and Belize, and both cases were lost. Successfully, we have 3 cases that were won on the challenges to buggery. Firstly, Caleb Orozco and AG of Belize on privacy and dignity. Importantly, in that case, Justice Benjamin ruled that the definition of sex in the Constitution of Belize also includes sexual orientation. Quite important for some of us who do not have a protected or an enforceable right to privacy. In Quincy McEwen and the Attorney General on the cross-dressing case out of Guyana, that was won on appeal at the Caribbean Court of Justice, and Tracey was very much involved with that as part of URAP, and can speak to that as well. Then we
Hello?
That was one. Oh, sorry, could you hear me?
Yes, I'm hearing you now.
Yeah, my internet went down a bit.
No problem.
There are currently 2 cases in the Eastern Caribbean that have been filed and the network is involved in the first case in Dominica on the challenge to buggery. That case is still in case management, I think, so that case is pending. And in Saint Vincent and the Grenadines, there's a case on buggery, but Zita Barnwell is on the panel, and she's one of the lawyers in that case and can answer any questions on those. Next slide. Next slide. Right. So I wanted to talk about the Eastern Caribbean strategy, because given this landscape, ECADE has been since 2015 sort of preparing a litigation strategy. And when we talk about ECADE, you see the countries that are part of ECADE. It's not only the English-speaking Caribbean, but also the Dutch and some of the French countries. Next slide. So the ECADE strategy on litigation, do no harm. It started with a meeting in Grenada and with various parties. So some of the persons I've just mentioned, like Richard, and we have Human Dignity Trust and a number of organizations who are also part of that strategy, and lawyers and counsel, etc., were involved in the other cases, including Maurice, etc. We came together to develop this strategy. And we looked at some of the relevant considerations in moving forward in a strategic litigation strategy. I just mentioned it when Richie asked the question, the importance of community level involvement, particularly in our small settings, mainly on the basis that it is a community that will be necessary to safeguard the physical integrity of the litigants and, generally speaking, of each other because of possible negative backlash. Political will is important, and simply to recognize that there is very little political will in our environments. And we looked at the cultural and social climate. The media, it's very important in terms of who has access. How do we manage the message and messaging? So for example, we should be messaging securing human rights for LGBT persons and not LGBT rights, and that type of language. Then we have to examine global north and global south language. So in global north, for example, the language is around, queer, identification as being queer. It's not a language that resonates or is used in the region. So it's about being careful. And so when we involve the interested parties and other organizations who are assisting in that exercise, it has to be, if you want to call it, localized. We looked at cases filed and we distilled the lessons learned from them, very importantly from Caleb's case and from the cases that Maurice had filed. And then we looked at allies and antagonists and an assessment of those. Most importantly, focus on litigants, preparedness and safety. So part of this strategy, next slide, looks at that. So we looked at how does it fit into the human rights strategy? So how does the strategy fit into the overall vision for ECADE, which is human rights for LGBT people are respected and protected in law throughout the Eastern Caribbean. And you can see one of the priorities for advocacy was the mounting of constitutional challenges to discriminatory laws. We considered constitutional review processes, which at the time were underway in most countries, which Tracey explained, has largely been unsuccessful. This is not a case, and when we look at the cases that have been fought, so far there have been success in the cases that have challenged buggery in the wider Caribbean. Next slide. So strategic litigation in the OECS from an ECADE perspective has been focused on sort of a three-pronged approach. Litigation is one, but we have other advocacy and communication activities, managing the message and ensuring that the messaging internally within the community and our allies is consistent. And of course, community education and capacity building. Because a lot of the community organizations in 2015 were dormant or simply not existent. Mm-hmm. And over the period of time, between 2015 to now, to 2020, ECADE has helped to build the institutional capacity by ensuring organizations have structure, they are the registered entities, incorporated, etc. They have the governance structures in place, and they have had what is called security training. Next slide. So this is a bit of an idea of the design of the strategy, where we mapped out for each of the activities, who is responsible, how, and when they were going to take place. Next slide. I'm sure this will be shared. So in terms of ECADE, these are the countries where ECADE is focusing its attention. We've had Dominica and Saint Vincent they've been done by other parties. So ECADE is filing and has filed in Barbados. McLean Ramirez and Renee, who's one of the litigants, is on this call, and also the past chair of ECADE. Gill and Equals Inc. against the Attorney General of Barbados. That matter is pending. And we are preparing to file in St. Kitts and Nevis, Antigua, and Barbuda. Well, I think some of them have been, Saint Lucia and Grenada. And full updates will be given on these as they're possible.
Are you giving me notice?
Essentially, yes. I think you knew it was coming. So this is the issue, because we feel that the strategic litigation or litigation is the only way to really address some of these issues, constitutional reform and political will or amendment aside. Mm-hmm. So in terms of the arguments, strength of the key considerations are really three. Strength of the legal argument, we've done extensive review on that, and I should say URAP is a central part of this process, represented by Westman, and Tracey has been backstopping on work for the legal teams in each country. Resilience of the community in terms of the immediate short-term and long-term impacts. So that's why institutional strengthening was so important. And of course, the two-pronged messaging, building a unified voice and managing the messaging around the litigation. We have not focused on being too public, which is a distinction with what happens in the global north. We don't put out press releases. We feel that at the end of the day, it is essential to safeguard the safety of the litigants because of our communities. Next, and I think we're almost done. Next slide. Right. So that's the last slide. So moving forward, we feel that the LGBT movement and base organizations and allies are strengthened with the necessary skills to drive and manage that three-pronged strategy to promote the inclusion and respect for human rights of LGBTQ persons in the Eastern Caribbean. So there is a concerted movement forward on strategic litigation in the Eastern Caribbean, part and parcel of the wider initiatives in the Caribbean. And from an ECADE perspective, and I'm speaking on behalf of ECADE because I have been with many others, with Kenita, with Maria, with people like Richard who contributed in the beginning, with Maurice who contributed in the beginning, essentially with HDT, with CVC involvement, with almost all of the allies in the region who have come together to sort of assist in developing the strategy. And now it's going to it is in the final stages of filing the litigation. Thank you, Richie.
All right, thank you very much for such a comprehensive presentation. I trust that the slides would be available for sharing. I leave that to the admins. So Kenita, can you arrange? So I don't know how it is we'll do that, just given that this isn't being done live, but is being recorded. So I suppose we have to find a platform for uploading the slides so that it is generally accessible for the benefit of persons. Thank you again, Veronica. My next question goes to Ms. Zita Barnwell, who is the lawyer litigating the challenge in Saint Vincent and the Grenadines. Ms. Barnwell, my questions have to do generally with just your experience. So I wanted to know, for instance, since the case has been filed in Saint Vincent and the Grenadines, what backlash has been received as it relates to the litigants and also as it relates to yourself? Because I know sometimes that the lawyer also comes into the public crosshairs. And how have you been able to deal with it in terms of taking measures to mitigate the risks to yourself and to the clients? Oh, I also see that I think Mr. E.G. is requesting the floor. So perhaps before you can respond, Ms. Barnwell, we would like to give the floor to E.G. Mr. Ramdani.
Well, thank you, Richie. Very quickly, as I did indicate to my email, I don't know if you were copied in it. I couldn't spend more than an hour on this, and we've gotten to that point. Okay. I wish to leave you with one last word. I think this is a wonderful initiative that is ongoing. I'd like to commend the lawyers and the others who are doing all the work. I will say this: governments of the region have try to get it right, and we have an electorate that we have to work for, if I can put it that way. Sometimes these actions that you take, these steps that civil society takes, is very, very important to getting some of the changes. And I will say this generally, to getting changes that sometimes the government itself wishes to have. And so please continue with your initiatives. Please continue to file your actions. I am looking forward to seeing the one in Grenada. And then Richie will get his answer as to what we will do as a response to that. Yes. Thank you all so much and have a very good day, everyone. I must also tell you that I'm a Hindu and tomorrow is Diwali. Some of you and all of you may know that. And Diwali is the festival of lights, when good things triumph over bad things, when light replaces darkness. And so I'll leave you with this. Happy Diwali, everybody.
All right, thank you very much. Happy Diwali.
Thank you.
Ms. Barnwell?
Richie, we have lost both Zita and QC to court. They are not out of court yet, so they're not on this court.
Okay, I see. All right, no problem. Is Ms. Robinson still on the call?
Yes, I am.
All right, so perhaps, because I know that even beyond doing the technical legal stuff, Europe would have been heavily involved in the Belize case concerning bringing the general community on board. Why is that important in the general scheme of things? And are there any best practices that you can share for the rest of the persons, especially the attorneys who propose to bring matters, or who currently have matters before the court? What best practices would you suggest be employed to engage the wider community for support?
Thanks, Richie. I mean, Veronica's excellent presentation very much reflects all the lessons we learned along the way. And I think that's what is so strong about the ECADE strategy, that it's also the way in which they have engaged with others of us who have been in the litigation space around figuring out what went well and what didn't go well, and how you can learn. And that's all reflected in the strategy which ECADE has. I mean, we did a number of things before we started, you know, so I would say the conversation about litigation, and Veronica, Richard, certainly were in some of those early conversations because CVC facilitated many of them. We started discussions regionally. So it was very important for us to think of litigation as not simply national, but regional. ECADE, by virtue of who it is already imagined as a regional entity working regionally. What happens in one impacts others. And certainly in the OECS, where there's a common court, yes, the ECADE covers more than the English-speaking Caribbean. You certainly are going to have dramatic impacts from litigation in one place in another part of the OECS. So that's one thing. Being in dialogue beyond a specific jurisdiction is important. We also asked and dialogued with actors outside of the LGBT community who were involved in human rights work. So we felt it was important that the community that would support litigation not simply be the LGBT community, but a larger social justice rights-focused community as well. I think over time we learned lessons around the extent to which, for example, a lot of the litigation work is very male-focused. Women in the movement raised very, very direct questions for us about their exclusion from some of the early work, the conceptualizing, the strategizing, and the need for women to be central actors in the litigation, even if, as it was the case in Belize, but isn't in quite a bit of the OECS, there are no serious indecency provisions which criminalize sex between females as well. So I think the importance of the conversation reaching and integrally involving all parts of the community, all parts of the social justice movement is important. We litigated, of course, in Guyana on behalf of trans women, but where litigation is focused on buggery, or as it was in the case of Belize, carnal intercourse against the order of nature, it's very important that the questions be answered and asked. Well, what implications does this have for the trans community? Why should we care? Why should we be invested? Aren't we finding ourselves more vulnerable as you litigate in settings where we can't see where the beneficiary is? Hard questions, important ones in the initial stage and throughout the litigation. And I would say, Richie, as a final point, litigation doesn't go perfectly. It's a conversation. That's the way I put it. Litigation offers a space for voices that simply won't get heard in our current social, political context to be heard. It starts conversations, and our experience is that the conversations outside court, within communities, in the newspapers, in other places, are often more important or as important as the ones that take place in court. And those conversations can be predicted. One has to create, which is why it's so important to have, as ECADE has, both an internal communication strategy and an external one that reaches to the region beyond the jurisdictions where litigation is taking place, because you can't engineer exactly how things go, and you will have resistance. Resistance, there's a wonderful expression by Jamaican sociologist at UA Latoya Lazarus about the rise of church law. If you litigate, and the AG is now gone, even if the AG does not take a strong position on litigation, others will step into the shoes of the government and litigate the government's position, generating a whole set of new dimensions around the role of actors who are now critical in legal processes in a way in which they haven't been in the past. And as you heard from Veronica, managing all of the various actors is critical. Allies can create danger in the same way in which those who oppose do. And not every bit of litigation is well equipped to address all the needs which litigation will produce. And I think one value of ECADE strategy is that it is thinking about how it works strategically, not only where it starts litigation, but where litigation has already been started.
Okay, thank you. Thank you very much. So I'm just mindful that two of our panelists are currently in court and not yet available. So I'll just open the floor to general questions and just pull in some other experts that we do in fact have on call. So I know, for instance, that we have Richard Elliott, who is an advocate working in the area of AIDS law. And we also have Ms. Victoria Vassie from the Human Dignity Trust. So Victoria, I'll start with a question to you. One of the things that Tracey just indicated was it's important to manage all aspects of the case, including involvement with allies. I know that the Human Dignity Trust has been an ally, a Global North ally, in many of the global cases seeking to advance LGBT rights. They've been an interested party, etc., and have made submissions in various regards. What role do you see organizations such as Human Dignity Trust playing in litigation? And do you see there being any risks of HDT's involvement or the involvement of other organizations like HDT in specifically regional litigation?
Hi, Richie. Hi, everyone. Richie's just thrown me that curveball there. I'm not going to put my camera on because I'm sitting in a dark room and I probably look quite scary. So I think, thank you for the question, and thank you for the invite to this this event, which is really interesting. And Richie, getting on your Attorney General and hitting him with some of those questions was bold and beautiful. So good to see and good to hear his answers. So look, in terms of the sort of support and intervention and role of allies and international organizations, you say, you know, what is it? What can it be? And I think the truth is it can be many things, but it has to be what is asked for and what is needed. I think that's the starting point. I think that, you know, there is, you know, plain old sort of drafting and law and legal expertise, which can be given. And I'm sure that's always needed, right? Because there's an awful lot of regional expertise that doesn't need to be duplicated, but sometimes perhaps another set of eyes can be helpful, and sometimes perhaps a set of you know, resource for running around and doing some of the research that is frankly quite boring sometimes and takes an awful long time can be done. But I think broadly speaking, it has to be what is helpful and what is wanted and what is required. So that's to the first question. I think the second question about, remind me what it was, Richie. about
Right.
the benefits and the disbenefits of involvement.
The benefits and also the potential risks.
Sure. So the benefits, I think, are help. I think everyone needs, there's always benefit in discussion, and sometimes contributions may be right, sometimes they may be wrong, but I think discussion is always helpful, I hope. I think that's a benefit. I think another benefit has to be able to have a view of how things have played out in other jurisdictions. I think that has enormous help, and that can be from the point of view of the law and how legal arguments have gone, and using comparative law. So that's taking decisions that have come from other jurisdictions, perhaps on the other side of the world, and adding them into the cases, and also, just having a little bit of a sense of how they have worked, not just as they're presented in a judgment, but perhaps how they've worked, how they were presented, how they were argued, when they were argued, what went wrong. I think it was Tracey who was saying that, things go wrong and you need to learn and try not to make things go wrong again. So I think that may be helpful. Always with the, clear caveat that what works on one side of the world doesn't necessarily work on the other side of the world. But I think that there are commonalities, which, as long as a proper lens is put on all the issues and all the arguments to be able to make them work for the case in hand, the jurisdiction in hand, the litigants in hand, I think that exercise is helpful. And look, the risk, I think the risk, I think it was Veronica, lovely to see Veronica, mentioned, that these initiatives are initiatives that are from the ground up. And I think that the ECADE approach to these initiatives is very much from the ground up, and that's how they have to be. And I think that visibility of international organizations risks undermining that. And even if the international organizations are there to support or seek to support that ground up approach, I think that the optics can sometimes be difficult, but they don't need to be. And I think that, again, in each and every case, in each and every courtroom, every judge, every set of lawyers, every set of individuals needs to take a very careful view on what would be helpful, and perhaps sometimes an international comparative perspective would be helpful, and in other cases it wouldn't be. And the decision has to be made as to which way to go, and it's not going to be the same in every case. And in every different jurisdiction, even within the region, I suspect.
Right. I understand. Okay. Thank you very much. Thank you very much.
No problem.
I just wanted to pose a question as well to, give me one moment. Let me just get the full name, Mr. Richard Elliott. Now, so far we have been discussing litigation concerning LGBTI rights. And oftentimes, because the science is now clear, in the case of, for instance, gay men who have sex with men, that the rates of HIV transmission tend to be higher, the rates of prevalence. But that is because, of course, when you stigmatize and criminalize persons, then they tend to go underground, they tend to avoid medical care or adhere to medication regimes. So for all the reasons, we understand that these laws do impact the LGBTI community. But besides buggery laws, which have sort of been the focus, in the world, generally speaking, have there been litigation cases concerning serostatus that you would like to make us aware of, that you think might impact the LGBTI community, and which might have potential of being replicated in the Caribbean?
Thank you. I wasn't expecting to speak, but thank you for the invitation. There's obviously been a lot of litigation about HIV on a range of fronts. I think it's related to the issues being discussed here, but much of it is distinct from the issues about decriminalizing and destigmatizing
Right.
LGBT people, which I think is the focus here.
Right.
So I think it might be worth noting that in the 3 proceedings that we have been playing a supporting role as the HIV Legal Network, that is, well, 4 proceedings actually, but 3 dealing directly with the question of criminalization. The first being the long-running and very slow-moving challenge to the buggery and indecency provisions in Jamaica. The second being not a domestic legal proceeding, but a petition to the Inter-American Commission on Human Rights filed by a trans woman, a lesbian, and a gay man from Barbados. And the more recently filed domestic challenge in Dominica, filed by a gay man. There has been reference to the connection to HIV, so the extent to which criminalization obviously worsens access to health services, impedes HIV prevention efforts, is detrimental to health of LGBT people, and of course people who are living with HIV. But that is only one part of the framing of the argument, and there are a number of human rights claims advanced in those cases. It's not just about HIV. That's just a part of the larger advocacy effort. And to just note something, perhaps in response to some of the comments that have been made in this very rich discussion already, I think it's also worth noting that in those proceedings that I've mentioned, there is reflected in the framing and in the pleadings, there is discussion of the implications of these provisions, not just for gay men, for example, but how these laws are harmful to women, including lesbian women and trans women. And I think that is indeed an important part of the thinking. And so even in cases where the law has been generally understood as being focused on criminalizing consensual sex between men, we know that in some cases the wording of provisions, particularly when we're talking about indecency provisions, is not actually so narrowly drafted and does, depending on the context and its application, potentially also criminalize sex between women. But even where that is not the case, the environment to which it contributes of homophobia and lesbophobia and transphobia obviously has a ripple effect on the human rights, not just of gay men, but of other members of our community. And so we have tried to reflect that in the pleadings, because that is an important set of harms that flow from this, from these laws. Yeah, maybe I'll just stop there because I don't want to take up too much time.
No problem. And the ripple effects that you refer to, do they bear implication for HIV prevalence, treatment, etc.? So I'm just, I suppose what I'm specifically getting at is, I think it is fairly widely accepted that criminalization of anal sex, for instance, or LGBT behaviors drives prevalence among MSN. But to what extent do discriminatory laws also bear implication on prevalence for other communities, for instance?
Yeah, thank you for that question. Of course, we have ample evidence about criminalization and the punitive and stigmatizing environment more broadly being a contributing factor to HIV among men who have sex with men. We also have very strong evidence about the link between those punitive environments and HIV among trans women in particular. I think it's also fair to say we have less evidence at this point about the extent to which it fuels HIV among lesbians. That's just not, epidemiologically, has not generally been something that has shown up in the evidence the same way. But that's why, in part, we want to talk about broader impacts than just HIV being an important impact, but criminalization of LGBT people and stigma against LGBT people has negative health consequences for all members of our community, even if those manifest sometimes in different ways. So there's no question that that environment is harmful for the health of lesbian women, not just gay men, for example. But maybe not so much connected to HIV, that has other implications in terms of access to health services, sexual health, reproductive health for everyone.
Right, I understand. And Victoria, I mean, you might correct me, but I believe that HDT would have done a report specifically looking at the effects of criminalization on lesbian and bisexual women, which highlights some of the adverse health effects, generally speaking, of punitive and criminalizing laws.
Yeah, it's called, thank you, it's called Breaking the Silence, and it does exactly that. It looks at where women are directly criminalized by the criminal law, but also where the impacts of criminalization of others in the community have negative impacts. So yes, thanks, Richie.
Okay, thank you very much. My next question goes again to Tracey. Many of the panelists here and persons invited to speak have raised the issue of challenges being brought not within our regional court systems per se, but within interregional organizational judicial bodies such as the Inter-American Human Rights Commission, of which you were a part and just quite instrumentally placed for a number of different years. What is the importance, or how do you see those processes as potentially affecting the litigation that is being done or being proposed regionally before local courts in the Caribbean? Is there any interlinkage, or are they completely separate processes? Do they affect each other at all?
They definitely impact each other. And maybe let's start with a positive. And the positive is evident in the work on the death penalty. I think I saw Wendy sing on at some stage, but also the work on environmental rights. If you take the Maya Leaders Alliance case in the context of the Maya community in southern Belize as good examples. The litigation in the Inter-American system, and I want to come to this question about exhaustion of domestic remedies, has been really central in driving what judges do from the very beginning. In other words, I think if you want your best possibility of an outcome at your high court or Supreme Court, have a good decision on a petition, so in the case system, from somewhere like the Inter-American system, or in the old days when many of us were sending individual communications to the Human Rights Committee, which my colleague Arif Bulkan now sits on. And that's for, I want to offer a simple reason why that's the case. We are strong common lawyers. We follow precedent. It's much easier for Caribbean judges to pay close attention to a case on similar facts, a precedent, rather than some of the other outputs of international human rights bodies. Or judges struggle around what you do with concluding observations of a treaty body. They don't know how to make sense of some of the other sources, but they certainly know what to do with a case, a petition, which looks like a judgment. I know that sounds kind of bold, but I think that's the case. Now, here's the complexity. Well, before I get to the complexity, obvious benefit in death penalty work and environmental justice and indigenous rights cases that we have had these individual complaints before international bodies, or judges use those decisions well and have in the past reasonably well. The difficulty is that generally you have to exhaust the domestic remedies first before you can go to the international body. And typically, because certainly the older jurisdictions have had these restricted savings law clauses, which limit the ability to bring the claims directly to the domestic courts, it's been fairly straightforward to say, well, I don't have a good remedy at home, and I can't exhaust and I must move forward. I raise that because I think there are potential tensions if you are running both at the same time, that you have to be sure that the international human rights bodies are in a position to deal with your matter if you're also litigating domestically, or if you haven't litigated domestically. In other words, you want to think carefully about running both tracks at the same time, and when you run the international human rights body track, and how is it likely to respond to the question of exhaustion? Because you don't want to hold up the matter before the international human rights body, because a good outcome is helpful at the domestic level. So I think thinking strategically about across both bodies is important. And maybe a last point here, you know, the value for me of being in the Inter-American human rights system is the appreciation that it's not all the case system. I certainly think if you're Latin America, then the petition and case system is everything. But in some respects, it's other aspects which have been valuable to the Caribbean. So the country visits, you know, we should be trying to ensure the Inter-American Commission can visit Grenada or Antigua before a case is filed or during the process. What the Commission said in respect of the jurisdiction will end up filtering back into some important place. The hearings. And it's not always clear in recent times whether Caribbean organizations have been successful in getting the hearings in the way in which we used to. But there's so many different mechanisms. And I would say the same thing for the Human Rights Committee and other processes, treaty bodies. We want to utilize all the resources to articulate standards which will be valuable to us at the domestic level, including the litigation. Even though we know our judges aren't as well equipped to hear all of them, we can begin to make them better prepared to read them. And certainly in the Inter-American system, it's a process of accretion. One thing builds to the other. I can certainly tell you, before I joined the commission visited Jamaica. What the commission learned about the status of LGBTQ persons in Jamaica has been absolutely central to a range of its work, and will find its way in whatever the final opinion is on the Jamaican case. So the slow accretion of knowledge and information matters to international bodies and ends up having a potential positive impact domestically.
All right, thank you very much, because I can add to that to say that I know for a fact that in some of the regional cases, the rapporteurship, which you were instrumental in creating, has since produced a rapporteurship report on the general current standing of LGBTI persons within Latin America and the Caribbean, violence against them, etc. And I know that excerpts have already been used in cases. My final question to you in that regard is, I recall in or about 2016, when I was doing my master's in London, you were brought to do a guest lecture on the Inter-American system. And one of the issues that you raised were funding and resourcing issues which impacted the ability of persons to actually access the court, or the length of time that justice would have taken. Is that still relevant to this day?
For sure. I think Latin American organizations have a lot more sophistication in relating to the Inter-American system and long established channels of resources for engaging it. But I have a lot of admiration for the work of the LGBTQI coalition. I hope I've gotten the acronym correct, you know, which has worked over a long period of time. And I would say it is the only civil society grouping working in the Inter-American system that includes Anglo-Caribbean jurisdictions and civil society in a meaningful way. And simply to say to Richie, so yes, I think ensuring that the resources which we have for work around these issues include international work is important. But remembering that the international and regional human rights spaces include opposition civil society as much as supportive civil society. And so you are doing some of the same work domestically and internationally in not simply being heard by the body, having your ideas understood, but also managing the tensions and conflicts that arise as others are in the space. You know, I recently in a discussion with a class spoke about ADF in the United States. Very few of us in the Caribbean understand that ADF appears to have been central in Belize and central in funding the support in the work of the opposition work of churches in that litigation. Right. But ADF has been a party in multiple cases before the Inter-American Court, all over the world, in Europe and elsewhere. You know, single organizations are also playing an important role in shaping the space in which you and others are working.
All right, thank you very much. Thank you very much, Tracey. So before we generally wrap up, because we are drawing to a close, I would like to pose one final question to Ms. Veronica Cenac. Veronica, as a person who has been involved in the development of some of these Eastern Caribbean cases, and having a bit of experience with that myself, I know, for instance, that sometimes for an individual person of the LGBT community to be a litigant, to stick their heads above the parapet in that regards and just take all the nastiness and risk that comes with that can be difficult. What protective mechanisms are available to potential litigants? So I know, for instance, that in some cases, not necessarily to do with LGBTI issues, but applications can be made to anonymize the person so that the name isn't listed on the claim or pleaded documents. But what such things are available for an LGBTI person who might be willing, but who also wants to be protected in some way?
Thank you, Richie. Well, you mentioned one already, and we have that actually is in operation in Dominica. So in that case, an application was made for the name not to be reflected on the record, and so it is not, it's reflected by an initial. In terms of legal protections, other than that, that's about the only legal protection that we can think of. The protection really has to be around how the case is managed, by the lawyers handling the case, and which is why it has to be some level of training or capacity building of the litigants themselves in terms of explaining to manage their expectations in terms of the process, what are the various stages of the process, what is required for them at each stage of the process, etc. And that the case may go on for quite a bit of time. Even after it has been fully argued, the decision might take years, as in the case of Belize. Although there are now some rules in Barbados, I know new rules of court have been passed to limit the length of time that judges take to deliver decisions, which is quite excellent. And I wish the Eastern Caribbean had those same provisions, because we are known to have decisions pending, like in Belize, for years. So that managing that expectation. And one of the things is, so alternatively, we have in some of the litigants, or as part of the strategic aspects of the litigation, there are resources, if necessary, to secure the safety of the litigant by having the person removed from the country. If it becomes necessary, if it is a dangerous situation for them. And for them, the litigants, and as you say, they advocate. They may not remove all, but put in place certain security mechanisms, and security plans have been drafted for each of the and people have been trained in them for each of the countries where ECADE is planning, including Saint Vincent was also included in that regard. So that's some of the security things that can happen. I think sometimes we have been hit with challenges, and some of these challenges throw up new opportunities or perhaps better ways of doing things. So because of COVID-19 pandemic, in the Eastern Caribbean, certainly all of our court matters are being held over Zoom. So there's no requirement for litigants to appear. Well, nobody's appearing in person in any court right now. We are all connecting via Zoom. And so it creates a really excellent space for the litigants who are no longer in a public arena, you know, having to get into the courtroom, etc., on the day, etc. It also limits the public, well, I suppose to say, which is a bit of a constitutional issue, the access by media to the court, which honestly, it is a constitutional issue perhaps, and it has been, I think, attempted litigation in some cases, but I don't know what has happened, because these are public hearings and people need to have access to them.
No, I agree, but so I know that the constitutionality of these issues have been litigated in the UK and England. There was a very high profile case, I believe 2 years ago, I don't recall the name, where there was this guy who considers himself to be this public advocate and goes into courtrooms and reports on everything and seeks to record. But of course, some of the issues are sensitive, and in relation to, for instance, children, our laws have been clear that the legislators or the court is entitled to restrict the rights of media as it relates to what they can report. So, I mean, it hasn't, as far as I'm aware, specifically been litigated in the Caribbean, but I think that the principles can in fact be applied if it is that it were to be litigated, because of course, I don't think any court would doubt, provided that the adequate affidavit evidence is presented, that LGBTI litigants are extremely vulnerable.
Yeah. Tracy's just listed in the chat that there is a decision from the Turks and Caicos Islands on remote hearings. Okay. So I'm going to read it as soon as to see what the court decided. So there's a distinction here. These are constitutional cases that we are discussing, and there's the criminal cases, which it would be, it really ought to, it should not be an issue in terms of access by members of the public. Constitutional cases, and because, as you mentioned, the issues among LGBTI persons, I think honestly, just being in strict law, these are cases of national importance and ought to have public hearings. That's my personal view on it. On the other hand, in terms of the safety of the litigants, the way it is being managed now is more advantageous to the safety and protection of the litigants. But I believe that they are, if challenged, I'm not so sure that we would be successful, you know, to finding a mechanism to make the, to have the hearings public. Not all aspects of it, certainly, right? There's certain sections of the hearing at the not a case management stage, at the argument stage. But these are some of the mechanisms that can be taken, that can be put in place, both legally and from a let's say administrative position in terms of what the organization can do.
Okay, all right. Thank you very much. So at this point in time, I would like to again say thank you to all of the panelists. The discussion has in fact been deep and rich. I wish we had more time to expand on some of the issues that were raised, but unfortunately we do not. Some of the links have been shared. I know that presentation has been shared by Veronica Cenac, and I'm pretty sure that the administrators of this session will put things in place so that it can be accessible to the general public, and provided that this is published, this recording is ultimately published. And I would again also like to thank the organizers of this event, ECADE, the Pan American Development Foundation, and all of our sponsors. And at this point in time, I would like to turn over the session again to Ms. Kenita Placide, who was the person that you initially saw as opening the session. So thank you again, and to Kenita.
Thank you, thank you. And again, a hearty thank you to all the panelists making time on this busy Friday. It's never easy. I've heard so much. I want to thank also Victoria and Richard for allowing us to put them on the spot. Two of the partners that from time I was at United and Strong into forming ECADE have been at the side at one point or the other, discussing and strategizing as to what things look like. And just want to say thank you. But where we are now, really and truly would not have been possible if it wasn't for really the guidance of Tracey, And, just a few minutes ago, I just want to share with everyone that, where litigation is concerned, I think there are kind of a few persons that you go to and you ask those very difficult questions, and they find the easiest of answers to give. And so on one hand, I think for me, it's looking at the role Veronica has played into the life of United and Strong, looking at the role she has played into AIDS Action Foundation, and now more importantly, the Eastern Caribbean Alliance for Diversity and Equality, ECADE. And then also looking at how Tracey, regardless of what position you have held, from time meeting you in 2006, your schedule have never been too busy to at least give a short response or call whenever needed to say, let's discuss, and you being able to give whatever guidance that you can. Usually your answer and Veronica answer usually the same, interestingly enough. So I just wanna say a heartful thank you to both of you for really being the guidance, the major guidance that has led ECADE through a very thoughtful process. And I cannot say just the two of you, because then I'll be leaving out Richie and Westmin, God forbid. So again, just saying thank you. We only have 10 minutes left of your time. And at this point, we would like to invite our partner, Pan American Development Foundation, Chris Woolley, to really take us through a small presentation on just what this Tides of Change project, which is this panel has been part of, that you will be expecting over the next 2 years, because it is a 2-year project. Thank you, Chris.
Great, thank you, Kenita, so much for that introduction. And I'd like to thank all of our participants and panelists today, not just for joining us today, but for all the important work that you do in your careers and in your work on behalf of this very important cause. My name is Christopher Woolley, as Kenita mentioned. I'm Senior Program Manager with the Pan American Development Foundation, which is a 501, the nonprofit affiliate of the Organization of American States, based here in Washington, working throughout the Western Hemisphere as part of the Inter-American System. And I'm joined today by my colleague Faisal Hassan. Faisal, would you like to say hello very briefly?
Yes, hello everybody. It's an honor to be here. My name is Faisal Hassan. I'm a program manager at the Pan American Development Foundation as well, working on this project with Chris. And yeah, I look forward to meeting many of you in the future and working with you as well.
Great. Thank you, Faisal. So yes, I mean, I'd like to thank everyone for the great discussion today around the discriminatory laws that criminalize same-sex conduct in the Eastern Caribbean. We know that these laws are grave human rights violations, and that even if they're not enforced, they very much facilitate and contribute to an environment that facilitates violence and discrimination against LGBTI individuals in the Eastern Caribbean. And that's why we're very excited to announce the launch of this new project, Tides of Change, that PADF is implementing in very close collaboration with ECADE to support the work that's being done to overturn these laws and other work that ECADE and local organizations are doing to fight anti-LGBTI laws and norms. So if I could just share my screen very briefly, I can share a presentation. Okay, do you all see the presentation?
Yeah, I'm seeing it.
Yes, okay. Oh, I think we might have lost it. Great, so I will, so just to start, the Tides of Change is a new project that's being implemented by PADF and ECADE to support LGBTI organizations to fight violence and discrimination in the Eastern Caribbean. This new project is funded by the Global Equality Fund. The Global Equality Fund is a public-private partnership of many governments from around the world, along with for-profit entities and nonprofit entities that's dedicated to protecting and defending the human rights and freedoms of LGBTI plus persons around the world. And so this is the funder for this new project, which aims to reduce violence and discrimination against LGBTI individuals by strengthening and supporting local LGBTI organizations. That's really the key focus of this work, is to support the important work that's being done by local organizations in the Eastern Caribbean. This is a 24-month project that began in August and will last until 2022. And as I mentioned, it's being implemented by PADF in close coordination with ECADE. So I think most of you all know ECADE, but I do know there are some individuals from outside of the region on this call. So I just wanted to let you all know that ECADE is an umbrella organization that works with human rights groups throughout the Eastern Caribbean to work towards equality in the Eastern Caribbean, from Virgin Islands down to Grenada, and really aims to restructure and revitalize organizing for the LGBTIQ community in this region. Of course, Kenita and her team can speak more, but I did want to provide that just for those of you who are from outside the region. Meanwhile, PADF, we are the Pan American Development Foundation. And as I mentioned, we're a nonprofit affiliate of the Organization of American States. That means we work closely with the Organization of American States. We coordinate closely with other entities in the Inter-American system, but we are an independent organization, working throughout Latin America and the Caribbean on international development and cooperation projects. We work across 4 main pillars, which we don't need to go into right now, but democracy, human rights, and governance is a very strong pillar and a very strong area of work for PADF. That's why we're very committed to this new project and to seeing progress in combating the laws and norms that are harming LGBTI individuals in the Eastern Caribbean. And across all of our work, we really do commit to partner with, support, and collaborate with civil society organizations, not just in the Caribbean, but in other areas where we work around the hemisphere as well. So at this point, I'd like to turn it over to my colleague Faisal to talk a little bit more about PADF's work in the Caribbean, but then also to tell you a little bit more about the project activities.
Thank you, Chris. As Chris mentioned, we work across Latin America and in the Caribbean. And within the Caribbean specifically, PADF has a very long history in the region. PADF began as an independent organization affiliated with the OAS in the 1960s. And ever since the 1960s, we've had some sort of presence in the Caribbean. Over the last 20 years, our Haiti office has been our main anchor. Our Haiti office has our largest staff presence in the region. We did have operations in the Dominican Republic that closed in 2010, but our operation in Haiti expanded after the earthquake, and we've had many projects regarding disaster resilience since then. In 2017, it saw an expansion of PADF's operations in the Caribbean. We began working with USAID and other implementing partners in the Eastern and Southern Caribbean. And we've also been doing work with the U.S. Department of State's Bureau of International Narcotics Law Enforcement Affairs in Jamaica and in Belize and in Trinidad and Tobago. In 2020, we've seen an expansion as well. In our operations in the region, we've received funding from, again, the U.S. Department of State, but their Bureau for Populations, Refugees, and Migration to work on the Venezuelan migration crisis in Trinidad and in Guyana. And we are also, of course, happy to be working under the Global Equality Fund with ECADE as well in the Eastern and Southern Caribbean. For this particular project, Ties of Change, we have 3 components. ECADE will be leading our research component, which will be 3 important studies and reviews on issues affecting LGBTI individuals. So that deals with public perceptions, discriminatory laws, intimate partner violence. The second component is capacity building. So we're planning to have 2 in-person training events on advocacy, awareness raising, and organizational capacity. Obviously, dependent on the COVID-19 pandemic, we'll see how the methodology of how those trainings operate in the future. But we will be also having online webinars created for Eastern Caribbean LGBTI organizations as well throughout the project. And then the last component is a small grants component. So we have funding for small grants to organizations in the Eastern and Southern Caribbean for local advocacy and awareness raising activities. And that'll be done down the line of the project. Our focus countries, our primary focus for Tides of Change will be the 7 independent Eastern Caribbean states that criminalize same-sex conduct. So you see them there: Antigua and Barbuda, Barbados, Dominica, Grenada, St. Kitts and Nevis, Saint Lucia, and Saint Vincent and the Grenadines. Then our secondary focus will be other Eastern Caribbean countries and territories. And with participating organizations on Tides of Change will participate in training workshops, participating in webinars, receiving technical assistance, and they will be eligible for small grants. And the project itself hopes to accomplish a few of these indicators here, key indicators. So as I mentioned before, 3 studies that will be published and disseminated, training 50 LGBTI human rights defenders, strengthening between 10 and 20 organizations in the region, funding at least 7 small grant projects that support local advocacy and awareness raising, and of course, advancing decriminalization efforts.
Okay, great. Thank you, Faisal. So that brings us to pretty much the end of our presentation, but would very much appreciate staying in touch with all of you who are here in the audience today. If you're representing a local Caribbean CSO or organizations and you'd like to know how you could get involved in the project, please feel free to send an email to me, Faisal, or Kenita. Our emails are on this slide, and I'll put my email in the chat so that you can have that if you are interested in seeing if you'd like to participate in some of the activities or even extend your local expertise for other organizations in the region. We'd be happy to have a conversation and see how we could coordinate. The same with organizations from the global north or international organizations. If you're interested in, collaborating or seeing if there's areas for support of this project, we'd also be very interested in having that discussion with you. And everyone, if you'd like to be updated about project updates, feel free to send me an email as well, and we can add you to a short listserv that we'll put together so that you can stay informed about the activities and the results of this very important project. So with that, I will turn the floor back over to Kenita, and I'd also like to take this opportunity to thank ECADE and its staff for putting together this wonderful event. I know a lot of hard work went into making this possible, and so we definitely appreciate the work of Kenita, De La Maria, and the entire ECADE team on putting together this excellent event. Thank you so much.
Okay. Kenita, you're muted.
Thank you. And I'm here talking away, right? I just want to say again, thank you for all of you who have been able to make time to attend. I think it's very important for us to be able to look at even the persons who have been here. US State Department, not just through that DRL funding, but I just want to pull out the name of Jessica Huber, who through many forums have supported and had conversations that encourage the work that we do. Again, Richard, Victoria, thank you. One of the other organizations we have collaborated with, which is so very important, is actually Parliamentarians for Global Action. And I think one of the things that, as the individual leading ECADE, that has been so important to do is actually connecting those dots. We want to change laws. We want to change hearts and minds. We want parliamentarians or government to change their position, but also lead that position. And how are we connecting those dots? We look at where organizations like the Canadian HIV/AIDS Legal Network continue to advocate, especially around HIV, but also inclusive of human rights. And so that gives a little broadening of what they focus on. HDT is very focused on the laws and how can they challenge it, how can they look at where the loopholes are. And that comes with the experience of connecting the dots globally because of their reach within different regions. That is important. Parliamentarians for Global Action have given us time and time again, whether it was in the US, in Costa Rica, coming back to the Caribbean and doing dialogues and trying to get senators and ministers involved in conversations that shift them from this point to another in order to get the information, but also to get them to lead their colleagues in conversations that are more positive for LGBT folks. And even as we talk about the gains we saw in Barbados around the labor law and other inclusions of even around the conversation we see happening around civil union, same-sex marriage, what does that mean for the people? This would not come about if there was not a level of sensitization even within the government and the conversations that have been having to provide them with data, statistics, experiences of LGBT persons that help them to shift that needle. And so the work we continue to do, even as we say today, we also got in contact, actually they got in contact with us, Open for Business, who is currently doing a survey here in the Caribbean across 12 countries, looking at the socio-economic costs to exclusion of LGBT people. And that data is going to be very much relevant. And as we speak today, I could tell you through the funding of PADF, in addition to partial funding from Equality Without Borders, we have been able to conduct an attitude survey across all 7 OECS countries where litigation is happening. That information is going to be used to actually develop campaigns as to what that look like. It's an interesting one because we're still trying and keep all the cases ECADE is doing off the radar. We speak about it, but we don't speak about where it is. And it has given us some wonderful mileage in many of the countries during this COVID, where COVID is the concern and not necessarily the cases. So this is one of the things we have done in terms of keeping it off the radar. But something that's very dear and important to me is how do we continue supporting and building organizations on the ground, which gives them the strength in return to continue supporting the community that they are serving. And during COVID, we did 1 or 2 fundraisers to help get money just for, to get what we call free money. That you had the allocation for care packages, whether it was for paying rent or paying supplies for people, because we understood the impact of COVID immediately hit our tourism sector, which actually accounts for over 46% of persons employed in almost all our islands that we work with. And we understood that a high percentage of that 46% of employment was that of LGBT persons. Mm-hmm. So the pain we felt in terms of the impact of COVID, the impact of dengue, and now so we have been having rains off and on for the last 3 to 4 weeks, flooding and destruction of roads and stuff in different countries. When we look at Jamaica, Belize, Cayman Islands, Antigua, Saint Lucia, we understand that the impact of what we're going through is even now more demanding than ever. Because whilst we talk about LGBT rights within the law, we also have to look at the well-being of the individuals where their sexuality has nothing to do with it, but actually the existence as a citizen to eat, sleep, and just simply be a citizen at this point is actually challenged by pandemic and climate change and not necessarily their rights around their sexual orientation. So again, bringing all of this under an umbrella and embodying it is something that I do on a daily basis. And the team that we have here, some of them on this call, I want to say thank you. But for all of you paying attention right now and knowing exactly how we work and what we do, I think is forever so important. And as we go forth, you have the pledge from me personally, but you have the pledge from ECADE that we will always be looking forward to connecting the dots where we can and where we have to ensure that we're looking at the entire citizen, LGBT citizen, human citizen, citizen on a whole of any particular country within the Eastern Caribbean, because that's where we can make people start seeing people and not sexuality. And I think that's very important. So today I want to say again, thank you. If there's any person who'd like to take the floor now before we wrap up, now is your time.
I have to jump off. I have to jump off, I was saying.
Okay, I think we are definitely ending. I was just giving an opportunity for anybody else who needed to make a few words, but I've seen some things come through the chat. And again, just saying thank you, thank you, thank you.
You're welcome. All right, see you.
Goodbye to all.
Bye.
Thank you.
Thank you.
Thank
Bye-bye.
you. Bye-bye.
Yes. Thank you. Bye.